there were a couple, I have this little guide on the top that, there were a couple that I went through and dropped out last night. I emailed you on one of them. I'm trying to remember what the last one was. I think it was the simple assault, reasonable fear language. I took that out, and I took that out of the aggravated assault charge as well, since it's not charged that way. All right, with that, are y'all ready to proceed?
Yes, sir.
Ready.
Anything else we need to take up before we bring the jurors in?
No.
All right, bring them in. We will we'll see if they need a break when you get done with your opening. If they don't, then we'll let y'all go for about an hour, and then we'll take a break, and then we'll let y'all conclude, and then we'll hopefully be close to the lunch break by then, I think. I don't know what time. No one talked to me about the food getting here. Let me do. We haven't had. All right. We ready to proceed to closing statements?
Yes, Your Honor.
And Ms. Francis, you intend to go first and last?
Yes, Judge.
All right, ladies and gentlemen, Georgia law allows for the party with the burden of proof to go first and last for a closing argument. So Ms. Francis will get an opportunity to talk to you twice. Mr. Ray and Mr. Weaver will talk to you in the middle. I believe Ms. Frankish is going to handle the closing arguments for the state, and Mr. Fogus is going to do his best to remain silent. If he needs to say something, we'll probably give him the opportunity, but I believe Mr. Weaver and Mr. Ray want to split theirs up and want to both talk, and that'll be fine. I anticipate what's going to happen is Ms. Frankish is going to go for about 30 to 45 minutes, and then save an hour and a half or so for her final close. If we need a break in 30 minutes, we'll take a break. It's going to be a long day. Y'all are going to be sitting there listening for a long time. If y'all need a break, if we need this, y'all need to go reload your coffee, that's fine. We'll do it. I've told Mr. Weaver and Mr. Ray that we will stop about halfway through theirs regardless, and we will take a full break at that point and give y'all a chance to walk and stretch and grab a cup of coffee. We will go till when defense finishes their closing. It should be right at noon. We should have food available for you. We'll take a 30-minute lunch break. Then we'll start back with Ms. Frankish will resume her closing statements. Then we'll probably take another short break, and then I'll give you the jury charge. Then y'all will have the case. It's going to then take us another. We did a pretty good job yesterday at gathering up all the exhibits and everything for you, but we'll still have to get all that out there, but I'll give you instructions for that. But there will be another break before y'all jump in and start deliberating, just so y'all know. And then we'll also have to talk to the alternates and give them instructions. All right, with all that, Ms. Frankish, you can go ahead.
Thank you, Judge.
Oh, the power cord? No, but I have
Yeah.
USB.
So, yeah, power, it's your display is going to sleep. So plug a
it's
power
not.
cord into the laptop. It's on it's on the screen.
I know, I have a privacy. It's
Okay.
the audio that's not
Okay.
playing.
Oh, is
There's
it not
audio.
playing audio right now?
Maybe
Okay, we need to be on the same page.
Okay.
All right, and so I don't want to be confused, but I remember you telling me he's on the burn pile.
Mm-hmm.
Were you lying about Scott? Is Scott? I mean, you think what? I don't. You tell me what happened.
I can tell you that there should not have been as much damage as there was done.
I don't know what that means.
That body should not have been burned up.
This case is about Gary Wayne Farris.
And you're here because Melody Farris shot him, concealed his death by putting him on a burn pile on their property like he was trash. This is not a chess match or a well-played orchestra, as Miss Farris would lead you to believe. This is murder, and it is not a game. Murder is the highest crime we have, and it is your duty to hold people accountable when they commit that crime. Murder does not happen often in Cherokee County. You are in a unique position as a juror, as a Cherokee County citizen, to make sure that remains the case. And to hold people accountable who commit those crimes in your county, to your citizens. You have heard 3.5 weeks of evidence, maybe 4, I've lost count. But today, I'm going to go over the law with you and how you apply that law to the facts and the evidence that you've heard. The law instructs you to determine the facts The facts are for you to determine. We have presented you the evidence, the witnesses, the exhibits, but you get to determine what happened in this case. And then you will apply the law that the judge instructs you to those facts. You are bound by the law. After the judge instructs you on the law, as he stated he will do for about 40 minutes or so, you will be armed with not only all of the materials that we gave you, the evidence, but you will also have the tools, which is the law. You will be in the position to convict Melody Farris. We talk about duty a lot. A juror's duty. You took an oath. The object of the discovery, the object is the discovery of truth. It is your duty to seek the truth of what happened to Gary Farris. You are not to seek doubt. All of the evidence before you points to her guilt. It is not your duty to go through all of that evidence, to find all the holes that are unreasonable, and to come up with some hypothesis that it doesn't even make sense. Your duty is the truth. And see, the defense wants you to ignore all the evidence that points to their client's guilt. They don't like the truth. They're going to lead you in a different direction. That will not make sense. That is not reasonable. Stay on the path of truth, and you will come to the conclusion to convict Melody Farris. The defense is going to talk about the state's burden of proof beyond a reasonable doubt. As the state, we have to prove a case beyond a reasonable doubt. But that is just that, a reasonable doubt. The doubt of a fair-minded, impartial juror seeking the truth. If there's a doubt in your mind, it has to be reasonable to acquit. It cannot be a doubt that makes no sense that you have no answers for. That's not a reasonable doubt. And in this case, we have proven it beyond a reasonable doubt. All of the doubts that they're going to get up here and try to plant in your mind are not reasonable. And the evidence shows that. And the law demands it. The defense is going to want you to believe that this standard is unattainable. They may even show that stair-step picture that they showed an opening of each burden as it gets higher and higher with reasonable doubt at the top. You cannot define reasonable doubt with steps. It is defined in the law. It is not to a mathematical certainty. It is not beyond all doubt. Beyond all doubt is unattainable. Crimes are not committed for everyone to solve and know about every single detail. Crimes are committed and concealed because no one wants to be caught. That's what you have in this case. No square circles. Essentially, that's what the defense is going to want you to figure out. How to make this circle into a square. You can't do that. That's impossible. The pieces fit together and they show the truth. We asked you in jury selection about your experiences in your life, things that you've been through. We are asking you to bring your common sense and reasoning into that deliberation room. Do not leave it behind. Because common sense and reason gets you through life. That's what you need to apply to this case. You make inferences, you can make deductions, and reach the conclusions based on what you know, what you've experienced, the evidence, your common sense. That's how you'll reach the verdict in this case. In the beginning of this case, you were informed that you must be an impartial juror, not biased to either side. Impartiality. That's the starting point. And that she has the presumption of innocence. Well, that was 4 weeks ago. That was before you heard all the evidence. That was before you actually realized that she's just cloaked in all her lies. You no longer are impartial. You have all of the information, all of the evidence. And that leads to one conclusion, which is that she's guilty. She is no longer presumed innocent in your eyes. That is no longer where she sits. There are two types of evidence that the judge will instruct you on, direct and circumstantial. A lot of shows and podcasts and commentators, they all say, well, it's just circumstantial. Right? We've all heard that. But the law says you give whatever evidence, whatever weight to whatever evidence you want. There is no legal difference between circumstantial or direct. You could have the most convincing circumstantial evidence, and yet the direct evidence is just, well, maybe. Or you could have evidence that's actually both. Let me give an example. I have a 3-year-old, and the other night he was eating dinner at the table, and I ran upstairs to go get his sister's pajamas or something. We have a box of cookies on the counter by the cookie tin. They weren't in the cookie tin, they were in the box. And I come downstairs, and he had crumbs all over his face. There was a cookie missing. And so, based on that circumstantial evidence, I could infer my child stole a cookie out of that cookie box. I'm not going to infer that some cookie fairy came into my house and took it. That's not reasonable. But that is circumstantial evidence. Now, had the box been knocked over on the floor and the crumbs sitting there on the floor and my dog is laying on the couch licking his paws, well, that scene points to my crazy dog probably jumped on the counter, got a cookie out of the box and ate it on the floor. I don't have to see who took the cookie to know who took the cookie. And the scene leads me to believe it's one or the other. Because I know my child and I know my crazy dog. So circumstantial evidence is a conclusion that you can reach based on inferences. Direct evidence is something you heard, saw, tasted, smelled, Scott seeing blood on the floor in the basement. All of the testimony you heard, those are things that they experienced firsthand. The witnesses, it's direct evidence. There is no legal difference. You give whatever weight to whatever piece of evidence you deem appropriate. You get to determine the credibility of all the witnesses in this case. To do that, you can consider all the facts and circumstances of the case, and on the next slide there's going to be a non-exhaustive list of other factors. In this case, motive, bias, all of those come up. Scott, Emily, and Chris will not get their father back. Whether they get up there, they have no motive to lie to you because Gary's not walking back through that door. That's their mother. They have no reason to lie. They don't want this. They don't want her sitting there. They don't want Gary gone from their lives. All they wanted is for you to have the truth. Martha, she is the epitome of a credible witness. Look up credible witness in the dictionary. It's a picture of Martha Barton. She loved Melody. She knew it was the right thing to do to come in here and tell you people the truth because you need to know the whole story. She had no motive to lie. Consider all of these factors when you're giving credibility to a witness. All of the facts and circumstances which they testify, their manner of testifying, their means and opportunity of knowing facts, the nature of the facts, the probability or improbability of the existence of that fact, the interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. You actually weigh people's credibility every single day without really thinking about it. You choose who your friends are, you choose who you want around your family, who you hang out with at work. You decide that based on a person's credibility. This is no different. The nature of the facts, the nature about the facts of which they testify, let's talk about that for a second. David, Melody's friend, who came in here talking about his one experience with Scott in the driveway in the trailer, he didn't really have the means and opportunity of knowing the facts surrounding that situation. He knew Melody for like a second. Scott didn't know who he was. You know what Scott knows? Scott knows Melody killed his dad and is running around with Rusty Barton still and letting strangers over to the house and throwing Christmas parties. Yeah, he's going to be mad. His dad was just murdered and burned up in a burn pile on his own property by his mother. And now some strange man is coming and using his trailer. He's going to be mad. David had no perception of that. Zero. And he has an interest in the outcome of this case. He doesn't want to see his friend go to jail. We've talked about this. You must apply your common sense and reason to decide what testimony you believe or don't believe. Again, you weigh people's credibility all the time without even knowing it. The law allows you and demands that you determine who to believe and who not to believe. And some people, you can believe some things they say and not some things they say, right? Like Rusty Barton. He plays both sides. We know that. We saw that. He wants to stay out of trouble, yet he doesn't want to upset Melody. We know what he said was the truth about her statement, he's in the burn pile, because of the context in which he said it. We know the recantation is a lie because it makes no sense. why, if she gave that statement at Martha Jane's house after Gary's remains were found, why would Rusty respond with, "Don't tell me anything else"? And he references that 2:20 a.m. call. And then the call you just heard, he references it again. And that was August 2nd of 2018. That is a witness. You'll have to resolve the conflicts of his credibility. But he was up there long enough. Y'all know the kind of person he is. Use your common sense and reasoning. Now I want to talk to you about what she is charged with in the indictment. And you'll have a copy of the indictment in the back with all the charges in it. I'm going to start with 4 and 5. We've got malice murder, felony murder, aggravated assault, concealing the death of another, and making a false statement. I'm going to start from the bottom and then go to the more serious charges. Okay. First of all, let me say this. If the defense doesn't get up here and concede making a false statement, no credibility to that closing argument. Knowingly and willfully making a false statement in any matter within the jurisdiction of the government of any county. Like Michael Ray said in his opening, lying to the police. I lost count how many times that woman lied to those police. But specifically this charge is about being currently in an affair with Rusty Barton. And y'all heard that voicemail on June, I think it was 25th. It was like less than a week before Gary's remains were found. Call me back, love you. That affair didn't end a year before. She just saw the unraveling. She didn't even own up to any affairs. She lied about Ted Wiley. Oh, we were just friends. We were all just friends. We know that's not true. You literally left your husband and went to stay with him for a significant amount of time. And he had to take the stand and talk about their relationship. If they don't get up here and concede that, you can't give their closing any credibility. Concealing the death of another. Commit this crime by concealing the death of another, hindering the discovery of whether or not such person was unlawfully killed, i.e., putting a body in a burn pile to conceal that he was shot to death. Concealment. Now we're going to go to count 1, malice murder. Causing the death of another person, in this case Gary Farris, unlawfully and with malice aforethought. Malice. That's what this charge is about. Malice is doing something maliciously, which means you have an abandoned and malignant heart. Malice can be formed in an instant. Now, we have a lot of evidence of malice in this case. Malice is not premeditation or anything like that. It's not ill will or hatred, although we have hatred. She despised Gary. That's no secret. She intended to kill him without a legal justification. The state does not have to prove premeditation, although we have evidence of premeditation in this case. Taking that gun from Martha, telling Addison not to spend the night, she knew this day would come. There is no required time to form malice, like I said. Malice can be formed in an instant. Every time she saw Gary, she had malice. Felony murder is another type of murder, which essentially is when you cause the death of another during the commission of a felony. And in this case, that's aggravated assault. Aggravated assault will be defined in the next slide, but it's shooting someone or pointing a gun at someone. That's aggravated assault. And that caused the death of Gary Farris. We do not have to show in felony murder that Melody acted with malice, even though we know she did. This charge does not require malice. It just requires the commission of a felony and someone resulting in somebody dying. The judge will instruct you that aggravated assault is a felony. There needs to be what's called proximate cause to the death. So the felony has to have resulted somehow in the death or be connected to the death, which we have. The judge will give you a definition of a simple assault, so you know what assaulted means, assaulted another person with a deadly weapon. And he will also instruct you that a firearm legally is a deadly weapon. We do not have to prove injury, although we have that in this case. It's not required. You can assault a person by instilling fear, but that's not what we have here. We actually have a shooting, and we have a death. I want to talk about the state's burden. Like I said, reasonable doubt cannot be measured. They will want you to believe that that burden cannot be reached and it is unattainable. They will get up here and try to instill upon you that there's no way we can ever prove this case beyond a reasonable doubt. Well, that is just not the law. The law does not require beyond all doubt. We need order and justice, and that means we prove a case beyond a reasonable doubt. You have more than what you need in this case to convict Melody Farris. I want to talk about grave suspicion and mere presence because I assure you that Mr. Ray or Mr. Weaver will get up here and talk about how we just have grave suspicion of Melody. She was merely present at the home when he died. No. We have way more than that. What they have is a grave suspicion of Scott, which is based on speculation and conjecture. And that's what that charge says. You cannot convict on speculation and conjecture. We can't even indict on speculation and conjecture. That's not even probable cause. Mere presence. Scott wasn't even merely present in the home. He was merely present at the barn. Compare the two, right? Grave suspicion, mere presence. Scott Farris. They have suspicion based on what? He's 6'5", he has a messy apartment, he was in the military. I'm sorry, is that a suspicion these days? Do we have to suspect everybody in the military is a murderer? Grave suspicion, speculation, and conjecture. That's what they're going to throw at you about Scott Farris. That was all their defense witnesses. Well, I just didn't like the way he talked to me. Well, I'm sorry his dad was brutally murdered by his mother. I think he's allowed to be angry. But Melody, we're here because Melody is sitting in that chair. And we have proven beyond a reasonable doubt that she is the one that murdered Gary Farris. The judge is going to instruct you on what impeaching a witness is. It's essentially showing that a witness is unworthy of belief. You can attack the credibility, and he'll give you all those charges in the jury charge. We saw some of that here. But you know, the person whose credibility that was attacked the most is Melody's. I mean, you saw Amanda sit on that stand, and Mr. Fogus showed her the text messages of Melody lying to her about going to Minnesota. Did you see Amanda's demeanor? Betrayal, disappointment. That's attacking her credibility. She's not worthy of belief. Amanda knows that. Her other children definitely know that. They sat up here and told you that. To that same vein, consider the source of a witness's information. If that witness's information is coming from Melody Farris, it is not worthy of belief. That's how you impeach someone. Every crime must be committed with criminal intent. To determine criminal intent, you can consider words of the defendant, conduct, demeanor, motive, and any other circumstance that you deem relevant. We have a lot of intent in this case. We even have a text message where she says, "I told him I hope you die a gruesome death." If that's not direct evidence of intent, I don't know what is. Her demeanor when she found out about Rusty's statement, she was angry. She was mad at him. Her motive, she had plenty of motive. She's the only one that had motive. I've said this. She despised Gary. She hated that he was giving away their money, her money. That was the main motive. Rusty was a bonus. She was mad about that money. And you could tell that was her motive because after the offense, she was on a money hunt. It was all about the money. We'll get into that in the next close. Telling Addison not to sleep over, she had criminal intent that night to kill her husband. And she, one, didn't want witnesses. Two, never told her grandkids that they could not spend the night. Telling people to, shh, I thought I told you to stop talking. Everything she said and did in this case not only proves that she committed these crimes, but she did it with malice aforethought and an abandoned, malignant heart. She stood to inherit all of his money. She burned the remains of her husband for almost 39 years in the hopes it would look like an accident. All because she wanted his money and to live a life with Rusty. In my next close, I'm going to talk about the evidence and why the evidence and the law demands a verdict of guilty in this case.
let's go ahead and take a quick break. I'm gonna try to set up another microphone over here. All right. So we will try to keep it to 10 minutes. And y'all can go run down and get a cup of coffee if you need to. You can come unlock this. direct the audience that unless you're a member of the media, you cannot have your phones out. And I don't generally get bent out of shape about things when the phones go off during court. I just pretend I don't hear it until it goes off the second time. But if your phone goes off, you'll be removed from the audience. So, but media folks can have yours out and can be taking notes or whatever, but members of the public who have not filed a Rule 22 may not. All right. So make sure you have it on mute, and if you're not certain, or if you have some monitor like I do that will go off even if you have it on mute, turn it off. Well, I didn't put it back on after the other day, so I can do I can eat whatever I want at the moment. All right, Mr. Ray, go ahead.
May it please the court, opposing counsel, ladies and gentlemen. First off, on behalf of Mr. Weaver and Ms. Farris, thank you very much. I know that this has been, for y'all, a long 4 weeks, and definitely for all the lawyers, it's been a long 5 weeks of dealing with this case. And we note that you have been paying diligent attention, taking your notes, and we are very appreciative of that. And with that, and like I told you on October the 7th, when I did my opening statement, you're getting on the Farris wheel. And it is, in fact, this family is a soap opera. And I think through the testimony that you saw that. Now, first off, the indictment, Ms. Frankish went over the indictment with you, so I'll just touch on it briefly. Count 1, malice murder. Count 2, felony murder. Count 3, aggravated assault. Count 4, concealing the death. And count 5, making false statements. Now, this is just to point out, Ms. Frankish pointed out that, we're disingenuous if we don't just get up here and freely admit about count 5 making a false statement. So I'll just go ahead and give you a preview that Mr. Weaver is going to be coming up with. He does not have a PowerPoint. He's got 2 books and about 10 pieces of paper, and he's going to be specifically addressing that with you. But what I will be doing in mine is walking you through what the actual physical evidence was in the case, and we're actually going to start by walking through the front door of the Farris property. Now, first off, with reasonable doubt. Reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. Ms. Franklin said it to you. I said it to you in opening. The judge is going to say it to you again. Mr. Weaver is going to say it to you again. And Ms. Frankish was right. There is a stair step. I found that several years ago, and I have used it ever since, and I absolutely love it because it shows what reasonable doubt is. Because you're not finding this case and deciding this case based on reasonable doubt. It is beyond reasonable doubt. So it's a doubt that you can give a reason for. They have to go beyond that. They don't just get up to the reasonable doubt step and stop, because that's not guilty. They got to get up on that top step, beyond that doubt. And it is a long burden. Look at all the stairs. There's no evidence until a reasonable suspicion, probable cause, preponderance, clear and convincing, reasonable doubt, and then finally beyond reasonable doubt. They have not come even close to beyond reasonable doubt. The state has introduced a case to you and spent 4 weeks presenting evidence, and it is so full of holes, and we're going to go through all of those. Remember I told you about when John Luke and I were getting ready for this case, and he had kind of hit a wall that day, and he was like, I'm leaving. Done. Can't listen to any more interviews. There are so many hours and hours of interviews in this case. He was like, I'm leaving. And he went to the drugstore close to our office, and he was just talking to the clerk there, and she said, well, sometimes the greatest questions go unanswered. came back in rejuvenated the next day. And we're like, hey, we got a theory, because we do have a lot of unanswered questions. So what are just some of those? The questions that have no answers in this case. How about the easiest one? Where was Gary shot? All right, if you remember from that drawing from Dr. Gooding, and I'll show it later, he could have been shot here. But she also said he could have been shot here. They don't actually know where he was shot. They don't have an entrance wound. They don't have a wound path. They don't have an exit wound. And in fact, and I'll go over it more later, Dr. Arden stated that the bullet is lodged in the soft tissue, never entered the body cavity. In that fact, that bullet that they found in the burn pile, there's no way that it would cause death. It would cause some bleeding. He said it could possibly bruise the lung. But in his medical opinion, it's impossible that that bullet caused the death. How was he put on the burn pile? This trial started out, it was a week of establishing the fact that they have a tractor. And there are now hundreds of photographs of a tractor and an RTV. But how did he get on there? And we'll go through what the tractor and the RTV shows. Where is the gun? No idea. How about where are the bullets? No idea. Scott's odd behavior, and I'll talk more about that shortly. How did Gary even die? And that ties into where Gary was shot. You heard Dr. Arden say that he would have to say that the manner of death is undetermined and that the cause of death is undetermined. And he said that because that was his medical opinion. And he was very clear in stating that I am saying this because I just do not have the facts. And I have not been given the facts. And the state hasn't shown me the facts to be able to make to a medical certainty of what the cause of death was and the manner of death was. And there are countless others. And we're going to be going through several. So, walking through the crime scene. This is the front door of the Farris home. You'll remember from talking, or from the testimony of that point in time, he was an investigator, now he works at the school, Shaw. You remember him. Shaw stated that he was brought back in, I don't think he remember who told him to, but there was a blood droplet. I don't think my little pointer will work on the TV, but it's right there, kind of underneath the window in the middle of that hallway that there was a blood drop, a potential blood drop. But what ended up happening, that blood droplet was not collected or tested, and actually when they brought Agent Coffey out, or Agent Honey, they didn't even have her blue star it either. So there is a spot on the floor of unknown origin, and nobody knows actually what it is. Moving further into the house, into the dining room, and you'll remember, if I am facing this photograph, the door to the stairs to go down to Gary's living quarters, it would be to the left. Agent Honey sprayed this entire area, if you'll remember from her testimony, in Blue Star. Nothing. Not a single drop of blood, except for when you turn and on that same rug. That's the rug there, and that's up toward what would be the left-hand corner of the rug. There's a single drop of what she said is possible blood because it reacted to the Blue Star. Wasn't collected, wasn't tested. I asked her, I asked Shaw, I asked Stewart, can you take that, can you cut it out? Can you swab it? Yes. Yes. Have you ever done that before? Yes. Did they do it? No. They didn't do anything. They really took a photograph of it and said, well, good enough. And you're going to hear a lot of that in this case. It all seems it's a lot of good enough. And actually, they came in and they're sitting on the front there, which is perfect. Because a lot of them, if you heard us when we were questioning them, it's like, why didn't you do that? And what's the answer? I wasn't asked to. Well, when you're the government and you're investigating a murder, you should have some decency to actually take initiative in this case, especially if you're going to accuse a woman of murder. But they don't have any initiative. In fact, they had Kuykendall over there standing next to a tractor at 8 o'clock at night for no reason instead of actually investigating. They abandoned, and of course, Hayes ain't getting off the hook that easy, but that sheriff's office, they abandoned Hayes. They went out there and they investigated that crime scene, and they left, and then they just said, Hayes, you know what, you're the lead, it's on you. Figure it out. And just left it. That's why Pope had to go with him to Tennessee. He don't even work for the sheriff's office. He's an investigator with the fire department. And he goes all the way to Tennessee to interview Barton, Martha Jane, I believe, and also Rusty Barton, because he was left. But so there's no initiative. Agent Honay says, when I asked her, did you collect it? No. Why? Nobody asked me to. No initiative. Here's the other blood spot, and this is two separate photographs. One on the left is essentially how the photograph is taken if you just took it while we're standing here today. The second one is you turn off the lights, and you remember with Shaw how you got to manipulate the lights, and then I did the whole thing about instead of taking a photograph and manipulating it, why don't we just set the stage in the house to actually be able to show the luminescence of the blue star actually on a photograph instead of manipulating the photograph to maybe see the blue star. So, that one's been manipulated, but that's fine, because what did Honay say? It reacts like blood, but it could also be something else. Because remember, I went through with her different types of food that can react to blue star, different type of chemicals that react to blue star, different type of minerals that can react to blue star. So she said, I don't know what it is, and also, did they sample or collect it? No. So essentially what we have here is a photograph of something that proves nothing. The stairs were the same way. I was going to go in, put in the blue star on the stairs, but, not just going to sit here and beat a dead horse. They didn't do anything with the stairs. They said, well, there looks like blood. Well, we're not going to collect it, and we're not going to test it. So, good enough. Now the downstairs, we actually get some investigation going here. You see from 1, 2, 3, and 4. You heard with the GBI that essentially we were calling 1 and 2. That's EM1 and EM2. And that's just, EM was evidence marker, so 1 and 2. Now, those blood droplets are the DNA, blood DNA of Gary Farris. That is proven, that is a fact. 3 and 4 were not collected nor tested based on the testimony of Shaw and Thrasher, and Hayes as well. Side by side, up close comparison of EM1 and EM2. You can see the blood droplet of EM1 is a centimeter, a little bit smaller. EM2 is those tiny, substantially less, less in size than a centimeter, 3 little droplets. Now, the basement. We talked a lot about the basement. So I just put that in there from a backed away perspective of this. You can see there where the arrow is, that's about where EM1 was. It's essentially at the foot of that wooden spiral floor lamp. The projectile that was found in the basement is in between the cushion and the chair. And there's a close-up of the projectile. Now, here's what's interesting about the projectile. The projectile, they testified, did have DNA of Gary Farris on it. And I believe that they actually tested a piece of skin, is what the testimony of that was. But look at that bullet. It's in a very peculiar spot. According to all the witnesses that testified, there's no impact marks, there's no bullet holes, there's no nothing. There's no marks on the ground where this bullet landed or anything like that. And then when Honay got on the stand, because remember she blue starred the basement, and also with Kuykendall, since he's the one that found the bullet, no blood found around that bullet. The only blood is EM1, 2. That's the only blood in the basement. Around that bullet, there is no blood. So there's no blood found anywhere around the projectile. Now, Honay said she blue starred it, the whole basement. I'll show you another photograph here in a second. And also the GBI quantified that they examined the bullet and there were no textile fibers found on the bullet. And if you'll also recall with, I think her name was Bagwell with the GBI, talked to her about how a bullet can go through, especially with those types of bullets that you saw. And you'll have it back there. You'll see that the flanges that kind of go out, kind of got, almost looks like kind of teeth on them where the bullets opened up. And they talked about how that can go through and snag on clothing and things like that. And you could get fibers and other types of materials on the bullet, of which they found 0. Now, showing the basement out again, the little area, that's where Hone blue starred. And I asked her specifically, did you blue star on the couch and the chair and all? Her testimony was, and you'll remember this as well, was that she believed that she had blue starred the whole basement, but she would only take photographs if it showed the luminescent or presumptive blood. And she had no photographs of the couch. Nothing. Up here, any of the walls, and this applies upstairs too. Nothing found. Nothing found on the back walls, nothing found on the ceiling, nothing. The only thing found, 2 less than a centimeter drop of blood in the basement. Now this was admitted through Thrasher, I believe. Essentially, and this is a pivotal piece of evidence because when you're looking at the photographs, it's kind of hard to figure out, especially for you guys who hadn't been there and seen all this stuff, of actually trying to navigate that house. Very confusing, especially when you get in the basement. But you can see, and you'll have this back with you as well. This is the main floor layout. You've got the porch and all that. And I've taken this and I've put the little dot. So that first dot closest to the bottom, that's where they said they thought was blood, but they didn't do anything with. Then you move around and you've got nothing until you get to that little drop at the top of the stairs that Hone talked about, as well as Thrasher, and then that other kind of swipe mark closer to the family room and the drops going downstairs. Now, what I thought was interesting in this, and the reason for it is, so you supposedly have, because you'll remember Mr. Focus asking, I think he asked Hayes, did you have evidence of a violent crime being committed in this house? And he said yes. Okay, so that's your evidence of a violent crime. 4 supposed drops of blood that was never collected, never tested in this entire fair. Y'all saw the house. It's a pretty big house. But where else was nothing found? Or what else was found? So we got the living room. There's nothing. Kitchen, nothing. Breakfast area, nothing. Little hallway that leads to the bathroom and the mudroom, nothing. The hallway leading into the dining room, nothing. The dining room, there's just that one little drop that they didn't collect on the carpet. But other than that, nothing. Study, nothing. And most importantly, or second most importantly, that's the hallway that leads out to the garage, 0 found. Front porch, 0 found. Going downstairs, that's EM 1 through 4. You can see I've labeled it, the top 2 kind of bigger ones. It is hard to make a circle with a mouse attached to your keyboard where you just got to do it with your fingers. So pay no part of that. But also down here, so we got that, and we also got the projectile, right? So let's not forget that. But what else do we have? Well, we got nothing found in the media room or the workshop. We got nothing found in the bedroom. Nothing in the office, storage, utility. Nothing leading out of those sliding glass doors to the outside. And nothing leading out upstairs, going back again, no, don't do that, leading out the front door. This is pivotal. And also, you'll remember I asked, I think it was Shaw, and he hemmed and hawed around most of the stuff I asked him. But there's no damage to any of the doors, leading in or out of this house. So, any evidence of any dragging or any equipment being used or anything like that, and we'll get more into that later. But there's no damage to any of the door frames, the doors themselves, nothing. Now, this was, I think, aerial, one of them. And I put a little campfire, so that's my burn pile. All right, and that's a rough estimate of where it was. Y'all recall, y'all all walked down there. But what I wanted to show you is using this photograph is, so here, no blood is found. Here, no blood is found. Around the burn pile, no blood. No blood, no blood, no blood. Not a single solitary drop of blood from anybody. Melody, Gary? No one. And we'll go into the tractor, because you're probably like, well, what about the RTV and the tractor? We'll get to that. That just shows all of those law enforcement. You know, I could name, about who was there. You know, Hayes was there, Shaw was there, Thrasher was there, Eckhart was there, I think Hands was there, Ballard was there. I mean, all of these people, all of these investigators, all of these law enforcement officers, EMS was there, fire was there. All of these people, and not a single solitary drop of blood is found on the outside where they claim that a violent murder happened. The outside of the house. This came up because you've heard, you probably didn't know what a preliminary hearing was. There's no point to learn it now, but you heard you heard Amanda talking about it. I learned it at the preliminary hearing. And one of this photograph became a big deal actually in the preliminary hearing because you notice you can see the crime scene tapes. So that is actually taken on or around July 5th. And I know the grass is extremely different now than when you all went out there. That is actual, real, regular old grass. Not a single tire track, drag mark, none on that well manicured grass, or the surrounding mulch, or anything else. In fact, well, there's the Kubota. We'll go on into that. So, we spent a whole day establishing tractors. So we got the tractor, and then we tested. Or actually, Cockendall stood by with it for some reason. I think Stewart actually found the photograph on the left. That little solitary, tiny little blood drop on the step. Because if you actually look at the tractor, there's no step on the, what would that be? If you're standing behind it on the right side, there's no step. So this is the left-hand side of the tractor, and that's all it is. Now the other photograph, that's the Blue Star photograph that Hayes and Shaw took when they actually took the tractor and the RTV over to the sheriff's office. And they said that this was, number one, it wasn't collected or tested, running theme we have here. But they said that was indicative of blood because it illuminated. But then, out of nowhere, y'all been here for 4 weeks, and then we call the chief deputy. I didn't know he was the chief deputy. Thought he was still a captain. Found out he's the chief deputy now. So he got promoted. Found out, why did you call him the GBI? And I was going to ask him that anyway because he was the head of CID, so he had to be the one to approve it. And what did he say? Well, our Blue Star expired. So there's now evidence that the Blue Star that they used in this investigation was actually expired. And that they believed that it was necessary at that point that they needed to call in the GBI to do Blue Star testing because they didn't have any that wasn't expired. Nobody told you a single word about that. And all of the testimony about Blue Star by the sheriff's office until Pinion came and said, no, I called in the GBI because we didn't have any that was good. Not that it matters anyway, because yet again, not collected or tested. Now, the bucket. No blood, no DNA, zero evidence whatsoever. There is nothing that indicates that tractor was used to move Gary Farris's body at any point in time other than a tiny drop of blood on the stairs, and there's plenty of evidence that Gary used the tractor. In fact, it was his tractor. He can use it if he wanted to. And there's a tiny drop of blood on it. But where we're talking about a murder, we're talking about moving a 6'5", 300-pound man, we got to have a way to do it. Use the tractor. Nothing. Somebody that the state says was shot 2 or more times, and there's not a single drop, not blood, not skin, not sweat, not hair, nothing found in the bucket of the tractor. Also, the back. I was just thinking last night while I was putting this together that maybe they tied a rope around it, and we'll get into ropes and stuff later. But on the back of the tractor, nothing. Blood, actually no blood, suspected blood, or DNA, or any evidence whatsoever on the back of the tractor. So the front has nothing, the back has nothing. Now the RTV kind of shifted, and then it seemed to me like in the middle of the trial almost, or not necessarily in the middle, but during the physical evidence part that things kind of twisted. It was, well, we've got to abandon this tractor idea because that's not really working out. We're switching to the RTV. It's a little easier. So, of course, we got a Blue Star tested too. But there was. Melody's blood was found in the GBI testified that the DNA found on the RTV. Now, here's what's interesting though. L2 shifter, that's how it's labeled. You'll have a copy of the GBI report back there with you. That's what they call it. The problem is and nobody testified what the L2 shifter is or does. We have no idea. I don't know if that's what makes it go front and back. No clue. It's just called the L2 shifter. Now here's the Blue Star. Yet again expired on the RTV. So it is very hard to see, but so I'll put the circles around it. So that is on the, we'll go with the left side first. That's on the, looks like the driver's side of the Kubota. Those little drops, they said that was presumptive of blood. Then on the back, where that indention is on the left-hand side, there was a little blood there, or what they thought was blood. Now, and keeping the theme of this case rolling, not collected, not tested, not sent to the crime lab. Also, remember, because I asked who would that have been? That had been Shaw. I asked Shaw specifically. That tractor and that RTV, what'd y'all do with that, the Blue Star? And he was like, we hosed it down, the whole thing. Remember, we got a violent crime, a violent murder. The state's trying to say that this was potentially used to transport a 6'5", 300-pound man. Where there is absolutely no DNA based on the Blue Star, and actually their own physical examination of the RTV is actually in the bed of it. Nothing. And also the Blue Star was expired. Now, this just occurred to me just out of other reasons. I just wanted to go because people were just, you never know what a jury's going to think and what other people think. So you just try to cover all your bases. So thought about, maybe they used a winch to get Gary out of the house or something. But there's no evidence of a winch at the house. There's no evidence of a winch on the RTV. Four-wheelers, well, I ain't got a four-wheeler. Got an RTV that's got no evidence on it. No evidence of any ropes, cables, straps, sheeps, tarps, horses hauling, dollies hauling. That could either be, I call them hand trucks, or the thing, like four square with the four wheels kind of dolly thing. No evidence of that. No evidence of any device used to potentially move the body of Gary Farris. Zero. Not one. And you got all these photos, hundreds. I don't even know how much evidence we're actually up to in this case. Y'all can count it when you get back to the jury room if you want to. But there's probably 1,000 to 1,200 photographs alone. A lot of them are like this. That's why I put these three separate photographs together. It's like, look at all this stuff. But nothing is found. Now the house, I wanted to show you with that because of that. So, we've got none of these things to move the body. And then yet again on the outside, no drag marks at all. All across that grass. Y'all saw the leaves, how the, underneath the tree canopy there, how it is. So you can see that if you were dragging a 300-pound man down that hill, it's fairly steep, that there would be some evidence. And there's not. There's zero. Now, Melody's shirt, I just want to show you this. John Luke put this into evidence. And I'm just going to put gloves on to touch it because things get a little nasty when they've been in an evidence bag for 6 years. So, and we didn't do it with the GBI, who actually did the test of the blood. But when you look, because I asked Shaw photographs, y'all have those photographs back. When you look at this, you remember, there's the front of it. Shaw was saying there was blood down here or here. That's where he was saying there was blood. But where there was actual blood found, way up here. He didn't point that out. That's where the GBI actually took the cutting of the shirt and found blood. And whose blood was it? That was Melody's blood. Now, they called the other lady with the GBI, who said that she tried to run what was called a true allele test. And all true allele is just a computer program that can potentially try to separate two different types of DNA. And it couldn't do it. It just said that there was Melody's DNA and there might be the DNA of somebody else of unknown origin and unknown type. So we just don't know what it is. So it didn't work. So you got Melody's blood on her own shirt, and you also, on a pair of shoes, that John was also put in, there was a single drop of blood on Melody's shoe. And yet again, this is Melody's own shoe. Now, why is that kind of important for me? It goes to show the quality of the investigation. Because why take those things, send them off to be tested, if you're not going to do the basic thing? Hayes never own fault and didn't take any initiative. And yet again, when you're investigating a murder, you got to have some initiative. Because he took photos, wasn't asking about Blue Star, all that. He said, I wasn't asked to do it. And one thing is good, going back to Lieutenant Stewart, he works in the courthouse now, so I see him every day. And, I was even talking to him this morning. But at the end of the day, it's like, you got to do your job. Whether or not I like you. Lindsay and Allison over there, every day. Talk to them almost every day. See them every day. Most of the deputies in this courthouse. But I tell them the same thing. If you're going to charge my client with murder, then you better take some initiative and actually investigate. So the barn. They took photographs of the barn. That's it. That's literally it. And we had pointed out, and I'll switch aside in a second, just because we were going through, and I'll kind of lay the framework for this. What we did is who they got here late, and so they did not get a seat, are standing over there. There's two of them. Now, they had to go through and print out every photograph in color in this case. One folder that is from July 15th has 2006 photographs in it. And we had to print, and that's one folder. There's probably almost 3,000 photographs taken in this case in total. So we printed all of those out, and John Luke sat there listening to interviews, flipping through photos. And then I started going through and flipping through photos. And then we started noticing that, Scott living in the barn, and, he's a 30-something-year-old man, probably not going to be very clean. It wasn't too bad, but his living quarters, pretty nasty. Dog feces all on the floor. Not the cleanest. I'm kind of a clean freak, so I pick up on that. But what was curious to me, a 30-something-year-old single man living in his parents' barn, that bathtub and that sink are spotless. And law enforcement took no initiative to say, okay, this is kind of weird. The rest of the house ain't too clean. Why is this absolutely spotless? And also, there's a magic eraser in the bathtub. I mean, at a minimum, go to Blue Star. What if he was washing off blood? But we don't know, because they don't have initiative. Same thing, you'll remember, or you're probably wondering, like, why in the world are they putting these in the photograph? And I don't have it on a slide, but you'll remember downstairs in the barn. I think Mr. Fogus put in some, and I put in some too. There's that drain, and there's a water hose running over to the drain. We actually took close-ups of it. No Blue Star at all in the barn. And they had, they can't use the old, it's expired excuse, because they called Monet out there, and I asked Monet, did they ask you to go out and Blue Star the barn? What'd she say? Nobody asked me to. The bullet. This is just more for my own curiosity why I kept asking these questions. And the answers were kind of shocking. We know the bullet on the right. We know who found that. That's the one from in the basement. That's Kuykendall. He found that. But the one found in the rib in the burn pile, of who found it? Dr. Gooding, remember her, she was the actual anthropologist. She said she found it. Now, before she testified, Detective Westbrook testified. If you remember him, kind of the bigger man with the beard that we put in the photographs of Melody's car. He said he found it. Sally Sims, the coroner, who made herself a witness in the case somehow, she said she found it. And then everybody's favorite investigator, Shaw, he claimed he found it. It's just puzzling as to, what is supposedly a critical piece of evidence in this case. And you've got 4 of your own witnesses being the person who claimed to find it. I mean, that is simple. That's really the easiest thing you could have done. Because who saw it first? Documented, located, bullet, rib, done. But they got 4 people saying that they're the one that found it. Just doesn't make any sense. Like a lot of people. This is the GBI, the ballistics report, saying that it was a 38 bullet as found in the basement. And you'll see the way they differentiate it. 38 bullet basement floor, and then 38 bullet jacket. That's the one from the rib. When it says bullet jacket, that is the one from the rib. And that one is in evidence somewhere. I think it's probably in here. So you can actually have that packed in a clear case where you can actually look at it. And you'll also have, and I'll just talk about that while we're here, you'll also have what's called a bullet comparison sheet that Mr. Fogus put into evidence with Ms. Bagwell with the GBI. And what that shows is you'll see the comparison of the bullets. A lot of it probably won't make sense. But if you look at it, and from her testimony as well, you'll see that basically from the bullet in the rib, she based a lot of her assumptions off it based on the bullet in the basement. So the bullet in the rib is burned up, and I said, how can you tell what kind of bullet it is? And she says, well, I'm making the assumption that since the bullet in the basement is a Hornady brand, according to her testimony, I'm just making the assumption that the bullet is a Hornet A. And I would say assumptions isn't reasonable doubt. It certainly isn't beyond reasonable doubt. You'll also see things like the weight of the bullet and stuff like that. They're both very, very different. But y'all will have all that back there to look at. Next, we also learned that 357 Magnum can shoot a 38 special bullet. Pretty well uncontroverted. There's plenty of evidence about it. And you'll also, when you're looking at this document, you'll see that the GBI, they gave a list of possible firearms from the bullet comparison. And most importantly, she says this list is provided as only an investigative lead and is not intended to be an all-inclusive list. So short answer is, it's a 38 bullet. What kind of gun shot it? We don't know. But it may be some of these, or some like these. Now, bullets, these are what Scott had in the barn and in his bedroom. The one on the left is actually from his nightstand. And what kind of bullet are those? Those are 38 special bullets. 38 special, 158 green, lead round nose. American. And I also heard Scott talking about, actually he said it, Chris said he didn't own a handgun, never did. We know that's not true. But he's got this many 38 bullets in his immediate realm, so to speak. That's a lot of 38 bullets for somebody that doesn't have the ability to shoot a 38 bullet. But he did, because we know from his own testimony, he had a 357 Magnum. Now he claims it was stolen, and we'll get into that in just a minute. But, so that's a lot of bullets for somebody that ain't got a gun. Now what did he say? Well, somebody bought those over. Who? No idea. When? No idea. I mean, bullets fairly expensive. I'm not going over to somebody's house and leaving my box of bullets. Yet again, just doesn't make sense. Missing 357. And I call this you saw that next slide, the magic gun. We'll get into it, but so I want to talk just real quick about Scott's missing 357. So John Luke had introduced these with Scott, and it was Scott Defense 97 through 100. And you heard John Luke questioning him about where was your gun stolen and all that. He said it was down in Columbus when he lived down there. House got broken into, remember? Guns missing. They called law enforcement. So, all right, we got a stolen gun. You know, your gun gets stolen. You obviously report it because, you know, I don't want my gun being used in a crime coming back on me years later or days later or whatever. So, he claims to have reported it. So, we asked the Muskogee County Sheriff's Office, give us all records. I believe it was between a certain year time frame regarding a 357 Magnum, other firearms belonging to Scott Walker Farris that were reported stolen. We are requesting copies of any incident reports 911, and we asked for that to be between the years of 2008 and 2015. And Muskogee County Police Department, from the sheriff himself, Scott 98, in response to your open records request submitted to the Muskogee County Sheriff's Office, please be advised that the Sheriff's Office was not able to find information requested in your details you gave. Therefore, there are no documents that exist. So, Columbus is a big town. Had to call my buddy Cody, because he's from Columbus. Actually, I asked him what county it was, because I didn't know. So we found that out from him. Then we went, and so we went to Columbus County Police Department. Sent them the same records request, 2008, 2015. Good day. There are no records in our system for Scott Walker Farris. I did check our jail system as well. No records. He sat on that stand and told you, under oath, that his 357 was stolen. So what is more likely? That his 357 was never stolen, or that two law enforcement agencies lost the records of a stolen gun and a burglary that he claims to have happened? Now the magic gun. This, I have been on this case longer than anybody. Longer than all. I've outlasted every prosecutor. I don't even know what number I'm up to now. I've been on it longer than John. The only person who has been involved in this case longer than me is Hayes and Miss Farris, and then me. And this has infuriated me from the get-go. And I have waited for 6 years to get to stand here to talk about this gun and this absolute nonsense that the sheriff's office took hook, line, and sinker from that man's mouth on July the 5th. The magic gun in the basement. So what did Scott say this gun looked like? That it looked like that. It was chrome, it was a snub nose, he didn't touch it, he didn't take it out, it was in some kind of a holster, but he could see what it was. Remember, he didn't want to pull it out because DirecTV guy's there. And I would also tell you, you'll have back the the text messages that Gary tells him to come over, the DirecTV guys coming. Now you can read those and use your own common sense and reason. I can't tell from those text messages because Gary actually tells him, come here, I need to show you something. It's like SSR or whatever it is. And then they talk about DirecTV guy got pushed back to 2. And it almost seems like in those text messages, he's having Scott come over just to help with something that he's actually there. Not Scott's version where he's having to go over there to let the man in. So you'll have it, you'll read it. It's just a little something to think about. So that's what Scott says is that he finds or he goes to look for. First he finds, tells no one, and then he goes and looking for it on July 5th. So it's in the basement. Now Martha Jane, she's saved for the end. What did she say? Looked something similar. She actually said she couldn't tell what color. She didn't know what color it was. Now Jenna, that was out of the blue, got on that stand and said, August 2024, over 6 years later, here comes Jenna into their office and says, guess what? I saw a gun too. And that's what she told the investigators. And they actually made her, and it's in evidence, you'll have it back there with you. If you remember, we actually put it in 3 different photographs of guns and said, pick, what gun did you see? Wanting it to be that, to corroborate Scott and his lies. But nope, they can't hold it together to do something like that. She picks a completely different looking gun, wood handle, black, and that's what she said that she saw. And we'll get to the locations here in a minute. Now, Chris, on the other hand, yet again 6 years later, he hops up on the stand, and guess what? He's seen a gun too, but he didn't see it in Purcell Lane House. He saw it back in Alpharetta. Remember, it was just laying on the kitchen counter, and he's never told anybody, and he took it and he put it up on top of the refrigerator. And what did that gun look like? We don't have a photograph of it because it's not in evidence. But he said it was a silver gun with an ivory handle. Ladies and gentlemen, what I would propose to you, what that is 3 people trying to corroborate one. The problem is they just don't have the capability to hold it together because it's a lie. You know what Mark Twain said, that you don't have to remember anything if you just tell the truth. The problem is when you're lying, you've got to remember the details of what you're saying. So Jenna knew to say it was a revolver. She couldn't remember the color, couldn't remember the handle. Chris, same thing. He remembered the color, but he got the handle wrong. He also got the location wrong. He said he saw it. They moved to Purcell Lane in 2013, so it had to be before 2013. Chris never told law enforcement in all of his interviews, sitting there talking to Hayes and Kuykendall and Pope, never said anything about this gun. Jenna never said a word in over 6 years about seeing a gun in that basement. Martha Jane, yet again, she's got her own slide. 2019 to 2024, 5 years, 2 law enforcement interviews, nothing. And Scott telling law enforcement within minutes of arriving on July 5th. Remember what Chief Deputy Pinion said? He's literally just walking down the driveway to the house to get things checked on, and here comes Scott. And then he said, he changed the conversation, and he starts talking about a missing gun and affairs, and pointing the blame at his mama. Immediately. And you heard it from Amanda too. Amanda gets there, I'm going to check on that gun. You don't even know what's happening. You don't know where Gary is, supposedly. You don't know that might be a gun involved. You don't know anything. Why are you looking for a gun? Frankly, also, why are you these kids? Your dad's missing, and let's go through and let's look for his wallet. Let's look for guns. Let's see, where's his credit cards at? You got Emily days later trying to access bank accounts. Pope had to go out and freeze all the bank accounts. Took all Amanda's money. Hadn't done anything. Nobody accusing Amanda of anything. But all her money got frozen too. Remember, because I think she said it was about $800, and that's all she had. Now, yet again, when you're operating on your life, so you got to remember where things are. Scott said in the left-hand photograph, that's where the gun is. That's where he saw it with the DirecTV. Jenna, knowing it was the basement, but can't keep it in the same place, puts it over there in that thing. I don't know what it is. Armoire, whatever. Basically, it's on a whole nother side of the basement. If you remember, you'll have those photographs. The Scott location's up by the sliding glass doors behind the couch. Jenna's location is over essentially behind the bar. Two different locations. Now, here is my whole point of law enforcement buying this whole magic gun theory from the get-go. Oh, and also, Scott saying it was a snub nose. What does every human being that knows anything about a gun think when you hear snub nose? 38. That's just the first thing that pops in your head. 38 special, all that stuff. That's what people think about. So he was very clear in saying it was a snub nose. He didn't say it was 38. He said it was a snub nose, and he gave the color of it. But what has hurt me since 2019 is the fact of this. So, who stores their stolen murder weapon in the living room of the victim? Talked about, they're going to meet their burden, and I'm going to send you down rabbit holes and get you not thinking clearly about the evidence. This is their evidence, right? Their evidence is Scott located a gun in the basement. That gun is corroborated by Martha Jane saying that her gun was stolen, right? Because they're similar in the slide I just showed you. So they're similar. All right. Now, what intelligent human being, if you're planning to commit a murder, stores your murdering weapon in the living quarters of your victim? That is the most asinine thing I have ever heard. If I'm going to murder someone or shoot someone, I'm going to keep my gun close to me, in my part of the house, in my purse, in my pocket, in my car. I'm not going to store it in my husband, according to them, that she despises, behind the couch that he sits on and watches TV, where Scott claims that he sits and watches TV. What sense does that make? And that's why when you're talking about reasonable doubt, it says in there, in that law, common sense. Because you can't, there's no way that the state can explain that away. What, Melody's just so stupid she didn't know where to put a gun? If that's what you want to believe? That's ridiculous. This whole magic gun, it is the biggest farce I've ever seen. Bot Zone, just briefly, he did the CPAP machine, the Dell computer, all that stuff. CPAP machine, he used an open source, which just means free, program to interpret the data that he extracted from the SD card taken out of the CPAP machine. We had asked him, was that program approved by the CPAP manufacturer? No. Did you do any testing to make sure that the data coming out is correct and you can actually prove it that it's correct, verify it, when it comes out the other end? And he said he didn't do that because he had to essentially just dump all of the information into the program, and that's what spit out on the other end, all the dates and the usage and all of those things. So remember I asked him, I was like, why don't you just take like, July the 1st, plug it in, see if the data comes out and matches, then you've got it verified that this program's actually doing what you would expect it to do. And he said, well, I can't do that. I have to do it all at one time. So essentially we have a non-approved or tested open source computer program to translate the raw data from the SD card. So you can't determine the accuracy of the translation. Even Box couldn't say that it's correct, what he was testifying to. He can just say, here's what this program that's not approved says. Also the trail camera. Scott admitted to deleting the trail cameras on July 5th during the middle of the search for Mr. Farris. You didn't hear any evidence of Scott telling law enforcement in any of his questioning in interviews or anything like that about deleting the trail camera. You just heard that from the stand while he was testifying. But, talk about the trail cameras, so that is 12/12/75/2018. That is Scott. He admitted that's him. Amanda also identified him. That is him walking up to the trail camera. Now, what you may be wondering is, how do we know that that's when the photographs were deleted? Well, we know that because there is essentially a way to print out the photograph to where you can get the data, call it metadata, call it whatever you want, of each of the photographs that were on the SD card. The two relevant ones, you see on the top one, Scott walking up, and it says deleted at the bottom, deleted true. That means that it was in fact deleted. So every photo before Scott is deleted. And then he's picked up on trail camera at 12:16 and it says deleted false. He's walking by covering his face. So he essentially deleted it and then got picked up walking by it 4 minutes later. Now, what was his excuse for that? Well, just searching for my father. I think a gun's missing. I'm worried about his safety. Need to check the trail camera and, I just always delete photographs from the trail camera whenever I go check it. In the middle of searching for your father. State's evidence. All right, state's experts. Dr. Gooding, Pope, and Atkinson. Gooding was the anthropologist, Pope was the fire lady, and Atkinson was medical examiner. So Gooding, remember I told you this would come back up. Best we can tell, or the best she could tell, is that bullet found in the rib is somewhere around those black arrows. And remember she said, and this is important, I think, their own evidence is saying that bullet is front to back, right? Front to back. So, first off, the body got to the crime lab July 7th. Claims of projectiles on the inside of the rib. So, remember as Dr. Arden explained to you, bullet's going. Their expert says that bullet is front to back. That is her expert opinion. Fine. Dr. Arden said we accept that as a fact. If that is a fact, that bullet is here. It is lodged in the soft tissue in between two ribs and did not enter the body cavity. Therefore, that bullet could not cause his death. Claims trajectory is front to back. Dr. Gooding didn't know if the projectile lodged in soft tissue is from the front or the back, but says it's a sternal rib end. And so that's when I asked Dr. Arden about what is sternal rib end, and that is the ribs that are connected to the sternum, coming off at the end of the rib. In the front, remember, if you remember from his testimony, I was able to show him with the little hand on the PDF. Yet again, Gooding couldn't tell him, none of them could, tell me about any vital organs. And what Dr. Arden said is you can't say it hit any vital organs, and that bullet, if it went front to back and it's right here, it didn't go into his body cavity. Also, most importantly, Dr. Gooding found no damage to any bones by projectile or otherwise. So there is no evidence, according to the bones, really, or the soft tissue. There's no evidence of saw marks, cut marks, knife marks. No evidence to the rib where the bullet is found, lodged in between the two of them. It had not been damaged. And there's no other damage to any other bone other than thermal damage caused by the heat of the fire. So, looking at it from the state's case, they want to say that Gary Farris was shot 2 or more times. Right? If that is the case, he shot 2 or more times and not a single bone in his body that they can find was damaged. Now this is Dr. Pope. That's just a little snippet of her report because I just wanted to read basically her findings to you. She said that that's easier if I just read it. The fire that burned this victim's body is consistent with a single burn event where the fire was set and left to burn as a slow rendering fire. And then for some reason it says in parentheses hours. That remained undisturbed until discovered as a crime scene on July the 5th. The duration of the fire was less than 24 hours old. You'll remember from her testimony, she made that assumption based upon how hot the fire was when law enforcement arrived on July 5th, somewhere around 1 o'clock or so, 1 o'clock, 2 o'clock, whatever that is. Now the important thing is, that 24 hours. I also wanted to point out, so it's post-testimony that Gary's remains are in that state of cremation, being on the burn pile 24 hours or less. Okay. You remember from those interviews you were hearing where Kuykendall and Hayes are talking to Melody saying that we've seen people come out of house fires. We've seen people die in collapsed house fires, and they don't look that bad. They're not burned up like that. According to the sheriff's office, they don't even believe their own expert. Because she said it happened in less than 24 hours. And not a house fire, an open pit just laying there burning. And also, no accelerants, no gas, no alcohol, no nothing. Now, the reason that 24 hours I've always thought was curious. So, if the fire was 24 hours old, 24 hours old when they arrived on July 5th, 1, 2 o'clock, that means that the fire had to be set less than 24 hours or less before. So that'd been 1 or 2 o'clock on July 4th. Common math. Actually went over that with Pope, and she agreed. Because I do remember. I was crossing here and it was 1:09, if you'll recall. I was like, it is 1:09 p.m. right now, 24 hours ago. It was the day before at 1:09 p.m. and she said yes. So 1 or 2 o'clock, law enforcement's there. Fire's burning the fire's less than 24 hours old. Well, at 1:54, Melody is an hour away on the 4th of July, verified at Lake Lanier. So we know that it's about an hour or more on a major holiday to Lake Lanier. Amanda said traffic was horrible. Getting in was horrible. Also know Melody went to Target, had to go buy the chair. We don't know exactly when she left, but through the state's expert, it seems like less than 24 hours, unless you just want to say, well, less than 24, maybe it was 10, maybe it was 5, whatever. Use your common sense there. But if you put it around the time of 24 hours when that fire was started, according to their expert, Melody's in Lake Lanier. She wasn't even on the property. And that is verified by that receipt, that is verified by Amanda, that is verified by Cameron as well, that Melody wasn't at Purcell Lane, that she was at Lake Lanier. Now, Dr. Atkinson's report, you'll see, this is basically the summary of the findings that Dr. Arden was referring to. I probably should have put it up when I had it. But it says basically you can't find entrance wound and unable to assess direction of a wound path. And like Dr. Arden said, a wound path is a bullet going through bone and muscle and tissue and subcutaneous fat, being able to track the path. Now, Atkinson was the whole copy and pasting. I'll get to that in just a second. But he couldn't say what organs were damaged again. Remember, I asked him, did he die of blood loss? Did he, was his heart hit, lungs, liver, all of that? He says he don't know. They want to blame everything on the fire. Dr. Atkinson couldn't say to a medical certainty that Mr. Farris was alive when he was shot. He did not want to answer that question. And if you recall from his testimony, he started giving him this big, long spiel about how I was like, no, you answer my question. Can you say to a medical certainty he was alive when that bullet entered his body? And he said no. And that corroborates what Dr. Arden is saying. Dr. Arden, complete honesty, was like, I'm not saying that you can't say that this is a homicide. But I'm just saying, being academically honest with, I think his word, is I can't say that it is or is not. And when you've got is or is not, then you've got undetermined. And when you can't tell me to a medical certainty a man is alive when a bullet entered his body, then how can you say honestly to a medical certainty that a bullet killed him? And you can't. Dr. Atkinson couldn't say what rib the projectile was lodged in. He actually knew less about the rib and the bone than Gooding did. And the reason why is because he just copied, and he admitted to it, he copied Gooding's findings directly from cut and paste, directly from his report, her report, into his report. He never went out to that scene. He's putting things in this man's autopsy, talking about it was found on a burn pile, and here's what we did, and all of these things, saying that these things are factually true. But he didn't go there. He didn't do any of those things. He's basically taken somebody else's work, hadn't proven that he's actually, verified it, other than just who she is, and just said, this is true and correct. I'm going to say it's a homicide. Dr. Hard, I've talked about it so much. Remember, he just said, look, I think actually what he said was, I'm not going to say it's crazy, to say that y'all have listed this as a homicide. I'm just saying, y'all haven't showed me, excuse me, y'all haven't showed me, and he had everything, all the, he went over all the reports and everything. Y'all haven't showed me to where I can agree with you to a medical certainty. He's like, I'm not going out there. I'm not putting myself out on that limb. Dr. Atkinson, he wants to put himself out there on that limb, be my guest. But Dr. Arden was not willing to do that. And you heard, I think you said, 3,000 autopsies that he had performed, been a medical examiner for 40 years, still practicing, got his own consulting business, all of these things. He's got all the credentials, in the world. And he's saying, no, I'm not going to go out on that limb based on these facts. And that in and of itself is reasonable doubt. Other witnesses. Ms. Frankish wanted to talk a lot about Addison and the text message to Melody, because that means that on July 3rd, Melody was planning on killing Gary. There's absolutely zero evidence of that. There's no text message, phone call, search histories, where there was any planning or preparation on July the 3rd. In fact, you'll recall Addison and Chris come out to the house. They come out to the house on the 3rd. She had just landed. Addison actually says they left, and then sometime later she texted Melody. And Melody didn't say, no, you can't spend the night. She said, how about tomorrow? And in fact, she did spend the night the next day with Cameron. But also with Addison, and the whole reason I called Cameron, y'all are probably like, this kid don't know nothing. But she did prove one thing. Addison, who is Chris's daughter, who was interviewed a year later, who testified that she's only hadn't had any contact with Melody, but had contact with Chris essentially through her mother, because that's how she had learned about the death and all of those things. But she made it seem like when they got out to Melody's house that Melody was not wanting them to go outside, didn't let them go outside, making them go get a bath way too early. You saw the text messages. It's 8:30 when she tells them to take a bath. They sneak out of the house, go get in the hot tub. Now, what's important, what Cameron actually establishes is Melody wasn't acting weird. Melody wasn't restricting them to go outside. That they went up to the barn. They went and looked at the horses. They went and saw the animals. They looked for Gary, and both of them confirmed they were down in that basement, and they didn't see any blood or any bullet. Nobody did. Nobody did on the 4th or the 5th. Anybody that was in and out of that house. Oddly enough, the last person, best you can tell, is the last person to come out of that basement is Scott before law enforcement gets there, looking for his magic gun that nobody's ever found and that nobody's seen. He's the last person to come out of that basement. And then the bullet is found. Chief Deputy Pinion, we've already talked about him. Him and Scott, he's just trying to see what's going on, and he's got Scott in minutes throwing Melody under the bus. John Lambert, that was really just to show the weird dichotomy, because Scott and Chris and Emily wanted to get on the stand, or did get on the stand, and basically say, oh, Daddy dearest, I loved him so much, I miss him, I can't believe this. While at the same time, you got Chris robbing him blind, him actually saying he was stealing, him admitting that he had used his bank accounts because he had the account numbers and all that, which is illegal, and he was doing it without Gary's permission. Gary actually texted him and said, "Your stealing has got to stop." Scott texted Melody saying, "Is he gone?" wanting to know if Gary was gone so he didn't have to do anything anymore. That is not, those aren't the text messages of somebody who, you truly love this man. No, that was just their bank. And he was getting ready to cut them off. So Lambert, that weird interaction, he said, it wasn't fisticuffs like Mr. Focus likes to say. It didn't rise to that level, but he said it was just weird. And then Scott making the statement, "Can't wait till you're gone so I can get this," or something to that effect. That's weird. That's not the statement of somebody if you love your father. Dave Thomas, yet again, showing Scott's aggression. With a whole, Miss Frankish, she got up here in her opening and was saying, well, Scott's dad was dead and he had a right to be upset. And then she said, his trailer. That ain't his trailer. That's not his property. That is Melody and Gary's. He wants it to be his, but it's not. Just like they want the money, they wanted the house, but it's gone. They wanted everything. They acted like it was theirs, but it wasn't. And Miss Frankish bought right into it, came up here and told y'all exactly that. He's upset his dad died. He's got strangers using his trailer. It ain't his. The owner of the trailer was standing next to it with Dave Thomas when he comes up acting like a nut, then chases him halfway over to Versace. Martha Jane. She's known about this case since July the 5th of 2018. I'm almost July the 5th, 2018. In the middle of this trial, she called law enforcement and said that I have to tell y'all something. Melody stole a gun from me in 2019, and it was a .38. And when did she say that? After, and you'll have this back there with you, after she admitted to it, after you watched this man on YouTube commenting over Rusty's testimony. And the title of this video, Did I Just Crack the Case? Because that man said, and I asked her, that's where the gun came from. The next day, she is on the phone with Captain Hands telling the story about how Melody stole her .38. There is no evidence that she ever owned a .38. They got some .38 bullets, but also just to show you, those are Winchester, not .1 The .357 that her husband owned was still there, and it also shoots .38, so it makes sense that you could also have .38s. But there's no receipt. There's not a photograph of this gun. There's her words 6 years later saying that she's got a gun. Now, she sat on the stand and said, well, law enforcement never asked me about no guns. Yet again, July the 5th or the 6th, she knew Gary had been shot. And you don't think that that might be relevant then? It only becomes relevant when a little man with a YouTube channel tells you that it's relevant. And she admitted to that. She also admitted that she was embarrassed. She was furious at this affair that she found out about, essentially on live television. Now everybody in Tullahoma knows it. She said she got to hang her head whenever she goes. Rusty destroyed the Barton name. And I also asked her, you believe that a mother should always protect her children? She said, I do. And I said, when you saw John Luke and I crossing those witnesses, you were furious. And that's when Mr. Fogus started his objections about let her finish her answer. Let her answer. She's 85 years old. She might be 84 years old. She might be 84 years old, but she came up with this lie because of YouTube and this trial being on television. That's the only way that she came up with this. She wants to talk about, Ms. Frankish wants to talk about, her picture is in the dictionary next to the word credibility. She has no credibility. She watched this whole trial. She knows everything. She knew to even say what color the gun was because she can go back and watch Scott's testimony. What does she do? Yet again, can't get the color right. She got the holster kind of right. She can't get the whole thing because you got to remember stuff when you're telling lies, and it's hard. And I'm sorry, when you want to show up in the middle of a murder trial, 6 years later, 5 years after you discovered a gun being gone, and your excuse is nobody asked me, and it doesn't become important, until 2-3 weeks in, that's the definition of no credibility. And especially when you can't even prove to me that she owned a gun. And, you know, she's got an excuse for that too. Didn't like guns, she moved it all over the house, blah, blah, blah. Show me something. They got nothing. I'll go on for more, but I gotta hurry. How long have I gone? Okay. Real quick, motive means opportunity. Motive, they want to say it's money. All right. Melody had access to money. You've seen the house. She could buy whatever she wanted. Here's where they messed up, though. It was with the financial accounts. You'll look at those. You should have them back there with you. Gary had actually added Melody back on as a life insurance beneficiary in 2012. That's around the whole Ted Wiley fiasco and her leaving in Alabama and all that. Got in the back. Here's where they messed up. They did not prove that Melody knew anything about the existence of life insurance. There's not a single witness who has said Melody knew about the life insurance policies, that Melody knew that she was a beneficiary. In fact, you heard from their own witness, Martha Jane. She said Melody didn't know anything about their finances. She didn't know where the money was. She knew that she had a debit card and that she could use it, and a credit card, and that she could use it, and that Gary tracked her. But she didn't know anything about other than that. She didn't know anything about the life insurance. She didn't know anything about the 401k. She didn't know about the partnership stuff, though, because she called and asked about it. But that's it. They want to say that money is the motive, then you might want to establish some evidence that the person who's wanting the money even knows the money exists. The only thing that Melody knows about money existing in this trial that is a proven fact is a receipt in her car with $11,000 in the bank account. So with that, I'm going to just go ahead and end there so John Luke can do his part, but that's the confirmation bias. And that's what it looks like. You remember I talked to you about that in the opening. Confirmation bias. They got their beliefs and they leave all these facts. So with that, ladies and gentlemen, I would ask you to find Melody Farris not guilty of all these charges. Mr. Weavers, after a break, we'll be talking to you next.
All right, let's take, try to keep it 5-10 minutes. Weaver, go ahead.
Mr. Frankish, Mr. Fogus. Ladies and gentlemen of the jury, we're already halfway through a long day, and I'm going to try to be as quick as I can. You've heard my partner, Mr. Ray, speak about a lot of facts in this case, but I want to speak to you now about the gravity of the situation. What we're here and what we're asking you to do and why we're asking you to do it. You are a jury, and you're well aware of that. And I think Michael mentioned in my books, and this is a book I got on my first day of law school. It's the Constitution of the United States of America. And there's an amendment, the Sixth Amendment to the Constitution, and it's been in place since 1789. And it is the Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. I think we've given them a public trial. By an impartial jury of the state and district where the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and the cause of the accusation, to be confronted with the witnesses against him, back then it would have been him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. That's it. That is the bedrock of what we're doing. And it has been here for a very, very long time. I told you back in jury selection that I was only looking for my client 12 fair, impartial jurors honestly seeking the truth. And you all swore that that was you. And you have sat here very diligently, and you have paid attention and taken notes. And we've all noticed the effort and time that you've put into this. You have put in weeks of your life. You have missed time from your families, your jobs, to be here for this very, very heavy, important moment. And I also told you you had another job. And I don't have my PowerPoints. I go with literally what you guys are going to have to work with. This is the charge that the judge is going to read to you once Ms. Frankish is finished speaking in this case. And your one job was to hold the state, and that's my job too, is to hold the state to their burden of proof. What is it? I'm just very clearly and succinctly going to read it to you, and then we'll talk about it. And I'm going to talk about some other elements of doubt that I think we should discuss, and I'm going to sit down, and the defense in this case will be over, and we're going to leave this to you, the jury, who is the most important group of people here. And I want to know this. I've been meaning to tell you this for weeks, and I can't tell you this. My client, you may notice that she does everybody else in the courtroom. They rise for you. They rise for the jury. We don't. Here's why. You are a jury of her peers. You're her peers. We're on the equal footing. The judge sits above us all as he represents the law. And we are all under the law. So when the judge walks in, the bailiff says, all rise, we rise for the judge as the representative of the law that we must live under. But our framers, who wrote this Constitution, and then they had to go dig this up. We don't actually use these books much at the office, I'll admit that. The Constitution of the state of Georgia, which was actually adopted in 1983, so it's a much newer document. And it embodies the same principles in our modern time. Now, some may say 1983 was quite a long time ago, but not to me. It embodies it in our real time, in our real life to this day. Because our framers knew the government is, in fact, that's why we're here. That's why we're not part of Great Britain anymore. And even the modern democracies of Western Europe kind of think we're nuts. They think we're crazy. Because we have 12 people who have no association with the government and to come in here and decide the facts of a criminal matter, to check the government for that very reason. We left over there because we knew that the government should always be checked, not just trusted implicitly with power. So I just wanted to explain to you, my client is not being disrespectful. I told her to do that because I so believe that we are equals. We are peers. The burden of proof. The defendant, and still is, by the way, presumed innocent, because this case is not over. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of this case with the presumption of innocence in his or her favor. The presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged, or offenses in this case. No person shall be convicted of any crime unless and until each element of each crime is proven beyond a reasonable doubt. You're going to get this document. This is the indictment. These are the charges. They have to, every page of this indictment, count 1, count 2, count 3, count 5. Every element, every word has to be proven in each count beyond a reasonable doubt. It can't just be maybe. I'm going to slow down. No person shall be convicted of any crime unless or until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever. And the burden never shifts to the defendant to introduce evidence or to prove innocence. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. So here it is. A reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given arising from the consideration of the evidence, a lack of evidence, or a conflict of the evidence. After giving consideration to all the facts and circumstances of this case, if your mind is unsatisfied, then that is a doubt of the law. And you must acquit the defendant. It says the word must. But if that doubt does not exist, if your mind tries to convict the defendant, if the state fails to prove the defendant's guilt beyond a reasonable doubt, it is your duty to acquit the defendant. You will be given a verdict form for 5 counts. Count 1, malice murder. Count 2, felony murder. Count 3, aggravated assault. Count 4, concealing the death of another. And count 5, making a false statement. It is, in fact, a heavy burden. But I contend to you that the state has not come close. Mr. Ray is far more eloquent than me. Mr. Ray is far more intelligent than me, and his brain works in a way I truly am fortunate to have such a good partner. But he found that diagram years ago of the stairs. I've always used, I'll come down here and I use the bar. I say, a scintilla of evidence is down here. Probable cause or preponderance of the evidence is somewhere towards the middle of the bar. Clear and convincing evidence, which is not the standard in this case, is a little further up here. And then beyond a reasonable doubt is almost all the way here at the end of the bar. It's not all the way. I'm not saying it is. But I think this case that we have set and listened to, and I think it is, the time was taken as needed to get through the case. For you to see every bit and every element of this case. But here's what I think you have clearly seen. And this is the first doubt that I propose to you. That the district attorney's office and the sheriff's office and all law enforcement involved in this case, from day one, from the early minutes of the 911 call, which let's think who made the 911 call. It was that man right there. He was in control from the very first minute of this case, Scott Farris. Scott Farris was always in control. And the fact that he had to immediately control the case, to me, shows doubt. And I do believe it is a heavy doubt. When you look at everyone involved, every witness that you've heard testify, and that's another thing you need to know. You need to know that your job, and you'll be charged on this as well, as a witness. You are to determine the credibility of the witness. Now, I'm going to read the charge. There's not a lot to this charge, and there's a reason why. The jury must determine the credibility of the witnesses. In deciding this, you may consider all of the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. What does that mean? Here's what that means. Here's what I propose to you. From the day we're born, in the early years of our life, we begin to get a feeling when we hear people talk. Because the words coming out of our mouth sometimes aren't true. For example, if I were to have a bag, and say I told you that this bag was full, instead of shoes, it was full of $1 million. Well, I'm going to take this half of this $1 million and give you guys the other half, and we're just going to leave. But here's what you know immediately. You know that if I had $1 million in this bag, I wouldn't be standing here talking to y'all. You know that. You have that feeling in your gut. Because you know, you've sat here and watched this case, it's a bag full of shoes. It's a bag full of shoes that has no important evidence on it whatsoever, other than the fact that I think Melanie Farris cut her finger at some point and got blood on her shoes and her shirt. I think they've established that. And I think, and Mr. Ray did a very eloquent job, and I can go on, and I'm not going to, because this case has got to come to an end. But when you think about law enforcement in this case, and their response immediately, let's go back to July the 5th. Let's go back to the time that Scott Farris, who's sitting right there, goes up to Detective Kuykendall, who's sitting right there, and he gets in his car for an hour and begins to tell him the story of the missing gun and his mother's affairs. And in opening statements, Mr. Fogus talked about circles. Circles getting big, smaller, smaller, smaller. And I think circles will be talked about too when we talk about Miss Harris. But those circles were controlled by one man. And that's Scott Farris. The investigation of this case became one-sided. in that first afternoon. And I would contend to you everything that happened, and it's unfortunate for us in Cherokee County, for the jury, for Ms. Farris especially, that it was stuck that way. There was never any true regard or respect for the evidence that should have been gathered in this case. You saw it. 3 locations on this massive property. You've been there. You've seen it. That were not checked. All of the countless problems that Mr. Ray unfortunately had to kind of wrap it up because we have time limitations on how we've been up here for weeks. We can't continue on. That's your job. You as a jury are allowed to go back to deliberate, and you get to go through every bit of this. And there's going to be some of you that believe this, and there's going to be some of you that believe that. And the judge will tell you that you are allowed to hold on to those beliefs and stand up for those beliefs. It is that standard that gives you the true check on our government. You are the democracy. You are it. We're having an election in a week. Nobody's got to go vote. There is no draft anymore. Some people don't have to pay taxes. But the one thing you got to do, and y'all know it better than anybody, is when you are compelled into jury service, you have to come. We literally saw an individual brought in here during this trial who tried to get out of jury duty. You've seen it. This is the last duty we have because it's that important. You can take any fact that we may have talked about or even things we didn't talk about, and you argue about it back there. I'm not saying screaming and yelling, but if you got a belief, you stay with it. And you listen to other jurors, and you make sure they listen to you. It's truly that important. But I would contend to you that the fact that Thrasher, who came out to the crime scene, I believe she testified something to the fact that this was essentially the first crime scene she'd ever been on. And she totally and completely failed in intaking the crime scene in the house. And that complete failure of that investigation alone, I think that's a doubt. I think going further into that day and the fact that this investigation was completely veered in one direction, and that's to Melody Walker Farris. So much was left. And that's part of what you've seen in this case. We've been attempting to investigate this case because we ultimately feel that it wasn't. We believe that the complete ignoring of the barn is absolutely, it's just despicable, for lack of a better word. And because they never even looked over there, they never even used Blue Star or Luminol or intook any of those things, even though there were some clear signs that they maybe should have. Gary Farris's card was over there. Scott Farris's bathtub was perfectly clean. They're there. I mean, Michael Ray told you. He told you. We had all those boxes that sit back there, and y'all, I'm very analog. That's the way I am. So we had all these pictures, and I'm going through all these pictures for months and months and listening to all these interviews, and you guys have gone through most of those things. And sure, I got real frustrated one day. Michael's told the story, but I'm going to tell the story to you too. I think you need to know. So after going through this for weeks, preparing for this trial, hours on hours on hours, hundreds and hundreds of hours preparing for this case, I finally threw up my hands. I was my paralegal will tell you. Sometimes I throw up my hands and I'm out. Michael says, "Where's John Luke?" I don't know. So I have to go pick up my family's prescriptions at our local drugstore, and I go over to the drugstore. And there is this little, she's young, I think she's 17 years old. She loves to read. But I walk in and they're redecorating the drugstore. This is a drugstore that's been owned by one family in our hometown for about 70 years, Jasper Drugstore. So I go in there, getting my prescriptions, and she's like, "John, what's wrong?" So I tell her, oh my goodness. And she looks at me. 17 years old, redheaded too, unrelated. 17 years old, she looks at me and she says, "You know, Mr. Weaver, sometimes the greatest questions, they go unanswered." I mean, literally. Ton of breaths. The second she said that to me, it finally cleared it up. Because I've been running around trying to solve this case for 4.5 years. That's how long I've been on it. Mr. Ray was on it longer than me. But because it is not answered, that's a doubt in itself. I want to talk about a lot of the evidence that has been shown about phone calls and sexual relationships with Rusty Barton and the grotesque amount of time that was spent by the district attorney's office proving a point that was proven very quickly. And that's that my client had extramarital affairs. But also evidence was shown that so did Gary. And they were in an open relationship. They lived on separate parts of the house. And Amanda, I thought Amanda was a truly fascinating witness. And it's kind of sad that we had to call her. I think she's the only child that is impartial. She literally just looked at you guys and said, "This is y'all job." I believe in my mama unless or until she's proven guilty beyond a reasonable doubt. And I think Amanda is such a credible witness because she also testified she was with her mama the day of the 4th. Nothing was out of place. And sure, they were texting and they were calling. And you see all this back and forth bickering all the time between them. And that's the Farris wheel. The moniker that has come to be in this case. And I know we are all sitting on top of the Farris wheel, and we just can't wait for that ride to let us all off. That's y'all's job. And we're going to get there. But all the drama and all of the infighting between the siblings and the affairs and the relationships that have gone on. I mean, the affairs started in the mid-2000s. You got Angela Phillips back in the 90s, who may or may not remember if she had sexual intercourse with Gary. All of that insanity. That's their life. But it's not motive for murder. And that is what they have put and leaned so much of y'all's time into. Because they don't want you looking at this. They don't want you looking at what they didn't do to get to their burden. But let's go back to those phone calls the night before. Let's go back to the timeline. There's something that is absolutely bizarre to me. We did not find out until, I think it was last Friday, when Commander Harris testified that Gary Farris went to dinner, we think, by himself, the night he was murdered. We don't know. We'll never know. He was at least alive until 9:30 something. When we see the dot moving, if the science is true. But sure enough, he went to dinner. They never thought to go get a video of that. Let's go up there and interview somebody. Maybe he was with somebody at dinner. We'll never know. And I'm not saying that breaks open the case, but I contend to you that huge glaring hole in the timeline right there, I'd say. Scott had been out at the lake all day. Golfing, laking. And there was a lot of testimony heard about that and the life and the dynamic that he had on the farm. He referred to the farm as his. He referred to the farm as his property. It was his possession. I mean, his sister even called it kind of comical. But you saw, and you'll get to go back through any of those you want to go back through and see the communications between Scott and his father. What really was happening was that Scott was a grown man who had every second. So whatever they're saying about Melody has to at least apply to Scott. He was completely controlled by his father, financially. Bring me back that credit card. Where's my credit card? It better be in my wallet when I get back. Over and over and over. It's in the messages. You've seen it. You can go see it again. So that financial motive alone and that control, wanting something that's not his, I think that's a doubt. The timeline of the phone calls. You will have seen from Commander Harris something regarding activity in phone calls. But I think that you guys have enough common sense to know, and this is just some things we saw, that other days and other times you went back and extrapolated out over a year, sometime back in 2017, and we clearly saw that there was more activity the night before a baby shower in Nashville than would be alleged for Melody to have shot, killed, moved, and burned Gary Farris. This is no easy task. That's a doubt. All of the weapons that could have been used in this case, all of the bullets, the means, the ability, they started talking about those circles. They started zooming in on one person. And it's not Melody Farris. It's Scott Farris. He's sitting here today. All of it. But I think it starts to become clear why I'm doing this. Why am I dropping these bags? These bags are 40 pounds apiece. I've got a few more bags to go. But I want you to know that it starts to become very impossible when you add this up, that someone who weighs 120 pounds and move this. That is a doubt in its own right. But there was a person on the property who could. And that's Scott Farris. He's sitting there today. Adrian, if you could come assist me. Both of them, please. No. You can hold this up, please. This is 320 pounds. I am 185 pounds. And that's all I have. I think it is the heaviest doubt of all that they have provided you with no means, plan that this could have ever happened by Melody. They have established there was tractors on the property and RTVs, but as my client, or as my partner very clearly laid out to you, I'm sorry. As my partner very clearly laid out to you, they didn't do their job. They've provided no way that you could have done this. They didn't check the boxes. They didn't fill any holes of doubt. The state of Georgia has put my client under grave suspicion. That is exactly what they have done. They have put on her grave suspicion, the most grave suspicion of all, and that is murder. But the doubt, I contend to you, absolutely exists. I'm sorry I had to do this demonstration, but they didn't. They didn't show you what 300 pounds truly feels like. I'm not saying I'm the strongest person in the world, but that is as heavy as a thing as a person can move. And I'm almost a 200-pound man. No explanation has been given. And I keep bringing this back because the grave suspicion that they put on her was affairs, calling Rusty, all of these things. And I want to note about Rusty as well. Let's note a few things. And I know you've listened to it and you saw it. Pope, he threatened to arrest him. He threatened his own warrants against him the death penalty, bugged my client for over a year. No confessions. Her own daughter has lived with her for years and years and years. No confessions. Now I want you to know this too, and it's a charge that the judge will give you. My client does not have to testify. She didn't. She chose not to testify. And we talked about this in jury selection, that you wouldn't hold it against her, but the law is clear. The defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. However, the defendant does not have to present any evidence nor testify. If the defendant chooses not to testify, you may not consider that in any way in making your decision. Because again, the burden never shifts to us in the defense. I feel like there's been so much time that we felt like we're trying. I'm trying to get you to see the side of the story that was never investigated. I feel like we've been able to do that, but we didn't have to do that. This decision in this case is everything for Melody. Melody has had to live under this grave suspicion for 6 years. But now is the time that 12 fair and impartial jurors, a jury of her peers, can finally give us answers. I'm not saying that you guys can ever answer what happened that night. The greatest questions, I do believe, they really do go unanswered. And in this case, it may be some of you as it was me that day. Very frustrating. You want to figure out what happened. But it's okay to know that you can't. And I contend to you, ladies and gentlemen of the jury, that because you can't explain what happened that night, they have not proven this case beyond a reasonable doubt. And I ask you to please hold to your oath and find my client, Melody Walker Farris, not guilty. Thank you for your time.
All right, we're going to break for about 30 minutes. We may go, I haven't gotten word that food is here yet, but I directed them to have it here at 12:15, and so I may be closest to being on time that I have been for the last 4 weeks. So anyway, when food gets here, we're going to give you all a break. I'd like to be up and running in 30 minutes. If y'all still need some more time, y'all just let the bailiffs know, but we'll be up and running at least by 1 o'clock. All right, everyone can be excused. We're going to close the courtroom for the recess so the deputies can have a break. So we'll open the courtroom back up at 10 till, and then we'll see if the jury's ready.
beating and sexually assaulting his model girlfriend and keeping her locked away as his sex slave, and then using his medical practice to hide the evidence. It's an incredibly disturbing news story that we're going to break down for you right now. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. I honestly don't even know where to begin with this case. I guess the best way is, let me just lay out this sentence for you. A New York plastic surgeon who has offices on Fifth Avenue in New York, in Manhattan, is accused of mentally, physically, and sexually abusing his model girlfriend and allegedly turning her into a sex slave and then covering up physical evidence of that abuse through filler treatments. Process that for a second, because these are the wild claims in a new lawsuit that was filed out in New York by 25-year-old model Maya Willow Sias, and this is against 40-year-old Dr. Amar Mahmood. So I'm going to read you the opening paragraph in her complaint, in her lawsuit. It says, quote, "Over the course of 9 interminable months, Dr. Mahmood, who ironically is a well-known plastic surgeon, physically, mentally, and sexually abused Willow. After dating Willow for a brief period, Dr. Mahmood convinced Willow to move into his apartment at 325 Fifth Avenue in New York City. He then implemented his plan to exercise more and more mental and physical control over her through various forms of seduction, coercion, intimidation, violence, and on many occasions, the use of psychotropic drugs. In short, he turned her into a sex slave. And as evidence of this horrifying abuse, she embeds in this complaint extremely gruesome and graphic photos. I don't even want to say a black eye, because that's not what it is. It's swollen. It is purple. There appear to be bruises on her lips, her arms. The pictures are so disturbing, we're not even going to show them to you. But here's the backstory to get you a sense of what's happening. So if you check out the website for his practice, Alina Med Spa, out in Manhattan, it reads, "When under the care of Dr. Amar Mahmood, you can expect elegant, beautiful results. Dr. Amar specializes in regenerative cosmetic procedures and brings a rare level of experience and knowledge to the field of aesthetics. His warmth of character and genuine dedication to his patients has led to a loyal clientele who appreciate world-class results." The website lists that he has a bachelor's in biomedical engineering, that he graduated medical school from St. George's University, that he's a board member of the Anatomical Clinical Research. He's an associate professor at SUNY Downstate Medical Center. By the way, we also checked him out on TruthFinder. We plugged in his name and location. And aside from some of the information that we mentioned, no criminal history that we found. By the way, TruthFinder, great tool we use on Sidebar to get details on the people involved in our stories. But I'll tell you what, even if you don't work in true crime, it is just an excellent resource to honestly maybe give you some peace of mind. I mean, TruthFinder, after all, is one of the largest public record search services in the United States. And with a paid subscription service, you can get access to unlimited reports about almost anyone. So if you're go out to dinner, and they start a brief relationship right after that. And it's when she says she moved into his place that she, quote, soon encountered Dr. Mahmood's dark side and monstrous temper. She said that he would drink, that he would take the psychedelic party drug 2C, that he would take ketamine, other drugs, that he would have sex with prostitutes and would force himself on Sias. And a big theme in this complaint is that he would sexually assault her, including when she was unconscious, and that he would force her to participate in non-consensual sex acts with other people, strangers, including, she says, prostitutes. She claims that on one night she found him in the apartment with prostitutes. She demanded that they get out, and then she says he proceeded to violently violently attack her, throwing her to the ground, punching her, smothering her face with a pillow. She ended up losing consciousness. She alleges that as a way to keep her from going to the police, Dr. Mahmoud would keep her imprisoned in that apartment, monitoring her movements through cell phone activity, that he threatened her life if she left. She claims he even supplied her with antidepressants and ketamine to keep her compliant. And this is the allegation that is truly, truly next level, as if everything I just said wasn't disturbing enough. And yes, these are allegations, but disturbing allegations nonetheless. She claims that instead of allowing her to treat her injury, and namely here she's talking about a broken orbital socket, he used plastic surgery to cover up the evidence of the abuse, that he took her to his office, that he injected her with tear trough fillers, and she said, in quote, in a display of calculated cruelty, he didn't even administer anesthesia. She called the procedure excruciating. She then claims that in October of 2023, she finds Dr. Mahmoud with another woman in the apartment, and both the woman and the doctor proceeded to beat her up. She says she called 911, but, quote, Dr. Mahmoud, through a combination of seduction and intimidation, quickly convinced Willow to retract the call, which she did. Sayas claims she was finally able to escape in December of 2023, that she suffers from PTSD, psychological trauma. Her modeling career has suffered tremendously. Now, again, these are allegations, okay? He has not been found liable. As we know, everybody is innocent until proven guilty or, until proven liable here. The standard of proof, of course, in a civil case is much lower. But I want to talk more about this. And I also want to talk about if this could potentially lead to any criminal charges. So for that, let me bring in criminal defense attorney Adam Conta to talk more about this. Adam joins me on set. Adam, good to see you. Thanks so much for coming on.
Great to be here.
Just initial thoughts. I mean, my gosh, what a lawsuit.
In this day and age, it's hard to be shocked by these type of allegations anymore, but this is shocking. And it's such an appropriate preface to what then they lay out as the allegations here, because this is a level of depravity that's out of a movie. I mean, it's so shocking. It seems corroborated by both pictures and text messages that were taken at the right times to sort of add a level of truth to this. You don't know until you get in there and you start seeing the discovery, but the allegations are really disturbing. This is a uniquely terrible case that is really coming to light in a shocking fashion.
I've been covering the Sean Combs case for the last year, and I am still shocked by these photos and what I saw. And again, we're not going to show them. Everybody, you can look online, and there's different outlets who are reporting them. We're not going to do it. But you say this didn't happen, unless, what do I go back to? What was it, the Johnny Depp Amber Heard trial? It's makeup. They're manufactured. They were caused by something other than that. Unless I don't know how you argue against that.
I don't even know if you can do that, because in that trial there wouldn't have been evidence of broken bone to corroborate it. Here, what we're talking about and what you described as being an excruciating procedure is he didn't just give her a black eye, which is insanely swollen shut and dark in the pictures, but he shattered her orbital bone. And so the procedure you described is even more horrific, because it said that he put in the hypodermic needles, no anesthesia, scraping. She could feel it scraping on the bone fragments as he was cruelly just trying to fill the damage he had done. But I say that because there should be evidence of a broken orbital there. Along with those pictures, along with the timeline, it just makes it really hard to envision that this would have been either staged for the purpose of this lawsuit, or certainly even harder to believe that it would have just been makeup, as the allegations were in the Johnny Depp trial.
Do you believe she has consulted with doctors and medical professionals to document that these injuries were real before she filed this lawsuit?
I would think so.
Yeah, because
I think any attorney who had this come into their office, the first question is going to be, after, are you okay? Are you safe? What medical history do you have? Have you gone and seen a doctor? If you have not, you need to go from my office directly to do that.
And talk to me about, there wouldn't be surveillance footage in a medical spot like this. I believe there could be HIPAA violations, right?
Well, there could be, though. I mean, there wouldn't be cameras in the operating room, but we're also talking about people who are willing to do potentially this kind of damage on someone. So those aren't people who are operating within what we believe are normal norms of society. Who knows if they've got hidden cameras? That's not an allegation, but even in a medical facility where there wouldn't be cameras facing in on the operating room, there would certainly still be plenty of cameras in and around the waiting room, watching people come and go. That's almost standard. But if I had to guess, because it's their spa, because it's Dr. Mahmoud's spa, I'm going to guess that security footage doesn't exist.
But if it doesn't exist, that makes him look really bad.
Sure.
But there could be footage, and talk to me how expansive this could get in a lawsuit like this. Footage of her entering the building, footage of her exiting the building.
Forget the building even. We live in New York City, right?
Yeah.
And I've been practicing criminal law here for 20 years, civil law for a lot of that time as well. And we have watched as a society, grainy security footage, which is pretty unhelpful, to now everything is in 4K HD. Security videos are everywhere. Cameras are everywhere. I think if they start digging, it depends on how long cameras can be kept. A lot of places erase after 30 days, but there's still potentially the opportunity to find video surveillance that shows her coming and going from maybe even back to his apartment. So there could potentially be video cameras that lay out sort of their entire
Day 10 of the Delphi murders trial, and for the first time, the jury hears the voice of Richard Allen. He's charged with the murders of Abby Williams and Libby German. Today, the jury saw him deny the murders again and again and again during taped interviews and in interrogations with police. But they also heard the first of many alleged confessions that Richard Allen made in prison. Thanks for inviting us in. This is your Delphi Debrief here on WTHR+. Let's get you right to Delphi, where our senior investigative reporter Bob Siegel and reporter Emily Longnecker are there. So Bob and Emily, what did you make of seeing these videos in court today?
Scott, today was, in some ways, it was overwhelming. I mean, it was just jam-packed today, starting with videos and then just witness after witness, the most witnesses we've seen of any day so far. And as you mentioned, we got to hear from Richard Allen. That's really the focus of today. And Emily, we didn't hear Richard Allen in court. He didn't speak at all.
Nothing.
But we got to see him on video, speaking on video. We got to see one of the notes that he wrote. We got to hear what other people heard him say. Right. This was really focused on helping the jury hear specifically from Richard Allen.
Absolutely. In that first video, October 13th, and in that second interview from October 26th, in that second interview, we get to see Kathy Allen come in and interact with her husband. And of course, she was in the courtroom today, watching herself on video, watching them interact. And we'll talk about that in a bit and some of the exchanges between them.
Let's set the scene for you right now. We are just across the street from the Carroll County Courthouse. It is directly behind us here. We can see it lit up. We're actually inside tonight because it's crazy windy here in Delphi. At 5 o'clock and 6 o'clock, I tried to hold my notes outside. They were flying all over the place, so we decided we're going to move inside. So we have all of our notes in front of us, and 30 pages of notes today. I filled up an entire notebook in just 2 days, just with all of the witnesses. So let's get you quotes. Yeah, let's get you caught up on today's witnesses first. Here's today's testimony. We started with those 2 interrogation videos of Richard Allen back in October of 2022, just right before he was arrested by investigators. We heard from John Gallipo. He's the former warden at the Westville Correctional Facility. He testified before the jury today. And then we heard from just a whole bunch of correctional officers, 7 Westville correctional officers. We heard from Ethan Drang, Michael Clemens, Michael Roberts, James Early, John Miller, Brandon Fisher, and Raymond Smith, all of them correctional officers who got to hear statements made by Richard Allen while he was at the Westville Correctional Facility. And we also heard from one additional correctional officer, that's Jason Bedwell, and he is a correctional officer at Wabash, where Richard Allen was moved to between the time he was in Westville and between the time that he was moved here to, before he was moved to local jails, which is what his defense team was wanting all along. So let's start off by talking about those videos which took up the entire morning of testimony. The day started off with 2 long videos showing Richard Allen being interrogated by state police. The jury got to see how Allen responded when he was questioned by investigators in October of 2022. This was 5 years after he voluntarily contacted police right after the murders to tell them that he was on the trails and on the Monon High Bridge on the day that the murders happened. I thought from looking at the videos that Allen was very respectful and calm in that first video. He offered information willingly. He appeared relaxed and animated while he was talking to both the Carroll County Sheriff and to one of the main investigators from the prosecutor's office, Steve Mullen. But once police told him that they wanted to search his phone and his car and his house, Allen, he remained polite, but he said at that point he needed to discuss that with his wife, and he told police, he said, "Your attitude toward me has definitely changed. This feels like you're interrogating me. You've known from the beginning I was out there. I told you that." And then Steve Mullen responded, "We're not mad at you. We're not upset with you. We're just trying to get the truth." And they asked Allen if he was the man referred to as Bridge Guy captured on Libby German's phone. They showed him the picture. And he responded, "It's not me. You're not going to convince me it's me. I had nothing to do with those murders." And he then said, "We're done. Arrest me or take me home." And there was an interesting part in that interview where he also said, "I don't want to be somebody's fall guy. Please don't think I'm questioning your integrity. From this conversation, it's like you think I did it." And it was really interesting, Emily, to see